pleasure to introduce Kit Krieger, who's our BCPVPA Executive Director. From 1989 to 1984, he was responsible for training BCTF staff representatives and has sat at both local and provincial bargaining tables on both employee and employer side. So his presentation today is including some suggestions about how to effectively work with both teachers and support unions in your school. And I look forward to our presentation. Over to you, Kit.
Thank you very much, Kevin. You can see my background is in my 42.5 years in education. Actually, the majority of it was with work in the union. I was surprised when I came here how little attention has been given to the challenges that face our members in working in unionized workplaces with, in one case, a fairly challenging union. So the first slide that I'll put up is I tried to find a picture of me on a picket line, but when I applied for this job, I hired a consultant, and they actually expunged everything on the internet, and I learned today it was quite successful. But this is just an image that reminds you that the union presence in British Columbia schools is significant, and it has had a major impact not only on life in schools, but life in the larger society. So we do a member survey. We started our first survey in 2013 with the intention of doing one every 3 years. Our second survey was conducted last spring, and interesting results, consistent over the two surveys. 67% and 62.6% of our members think the collective agreement is a major obstacle to supporting student learning. And this is not about how to get around the agreement, but it shows the collective agreement, which you have a responsibility for implementing in your school, has a major impact on your work. And obviously, the better you know the agreement, the better you know how to work with it, the less the negative impact it will have. The other one is that 60% of our respondents in both surveys, again consistent over the two surveys, said they have never received any support coursework training on how to manage a unionized workplace. That's surprising, and I think that is actually a failure on the part of employers who perhaps don't understand the cost of not providing that support to our members. So here's the context of BC. It's a little bit different than other places in Canada. We were the second jurisdiction in Canada after Quebec, who removed the principles sometime in the 1960s. But BC, Ontario, and Quebec, interesting, the three largest jurisdictions in Canada, all have their principals outside the union. In every other province, and Kevin goes to meetings of the Canadian Association of Principals, and there's a real culture difference between those provinces, the 7 provinces, and the 3 territories where the principals are part of the union, and those 3 where they're not. And the labor relations climate, I've served on national boards such as the Canadian Teachers Association, and nobody doubts that British Columbia has the most challenging labor relations climate in Canada. Add to that the fact that our members come from the ranks of teachers. Many will spend, if it's 10 or 12 or 15 years, which it used to be, it's now tends to be quite less, but our members come up through the ranks of teachers and have some perspective that to some extent is influenced by their affiliation with, and in some cases, their attachment to BCTF, and it certainly poses challenges. When you become a principal or vice principal, you lose that affiliation, and I believe there's an identity crisis. We haven't explored that, but the kind of support you had, certainly, even when I took this job, I remember people talking about my going over to the dark side. Our duties as principals, vice principals are very clearly laid out in Regulation 5 of the School Act and Regulations. It's old. It goes back to the Act of 1988. Many of those, the items contained in there actually go back to previous School Act provisions. They include things like having 3 assemblies a year, including one on Remembrance Day, and making sure the flag is raised every day. But it does provide your authority to essentially run your school, and in particular to evaluate teachers. Really, you're responsible for the delivery of the educational programs to students in your schools. The other thing you should know is that the BCTF provides 4 days of training every year to union leaders, and 2 or 3 of those days are always given to the staff reps. They do provide sometimes training to PD reps and sometimes training what they call their social justice reps. But the major focus is staff rep training. The program that for training union reps started as only staff rep training. So they're getting 16 hours of training a year. Those who've done the job for many years, and I suspect that quite a few of you are in your schools where people have been staff reps for 4 or 5 years, they're getting, somebody might have had 100 hours, 200 hours of training. And because I ran that training program, designed a number of those workshops, I will tell you that they are very, very serious, and they are not about how to make your school a better place, but how to make sure that the union interests are represented and that the staff rep has substantial influence over your school. The contract is the basis of your relationship with the union, and you are, in fact, the agent of the employer in your school. That is and the employer is really twofold. It's an agreement between the British Columbia Public Schools Employers Association and ostensibly your district and the union, and you're the representative of the employer, and the staff rep is a representative of the union. So in that respect, we get to a minute, it defines the relationship you have with the staff rep quite a bit differently. The signature at the bottom of the contract says this is what we both accept are the terms and conditions of employment for the term of the contract. That's very serious. It's a contract like a mortgage or an agreement to purchase a boat or anything, or a car. It's a legally binding contract that both parties have agreed to. As the representatives, you're both charged with implementing the collective agreement successfully. If you don't have a contract, the rights of the employer are simply unfettered. The only thing you can't do are things that violate the Charter of Rights, the Human Rights Code, or legislation like the Employment Standards Act. And in fact, I used to, when I would teach this stuff, I would hold up a blank piece of paper and I'd say, this is the ideal contract for the employer. Everything you have in that contract limits the power of the employer. And the union representatives know that. And it's important we understand that, because it's a very important principle. You don't want to surrender more rights than the employer has agreed to surrender to the union in collective bargaining. And for the union, it's very important. It's designed to make sure that everybody's treated the same, and again, to fetter the rights of management. Back to I said it before, that the union has its rep, the board has its rep, and for the purpose of this relationship, you are peers with the staff rep. Every other teacher in your staff, on your staff, and this is the same with the QP rep, or if you have another support staff union in your district, every teacher is an employee and a subordinate, and they deal with you. They have a duty of fidelity. They really have to defer to your authority. They don't always do so, but legally they do, and you can direct them in quite a number of manners. But for the staff reps, or the shop steward for QP, they are, when it comes to the task of the collective agreements implementation, and when they talk to you about the contract, they are your peers. And this was perhaps the most important principle that I used to drum into the staff reps. I had a hat, and I said, when you're in your union rep hat, you are the peer of the principal. You are not an employee. You're not a subordinate. Now, you can't take that peer status in all exchanges or relations with the administration, but you certainly can. So you owe that person a fair amount of respect and deference, and if you remember their peers and you base your relationship on that basis, it's a good thing. So, some things you should understand about the union relationship that will help you get along well with your union reps and not give away more than you should. Among the most important articles in the teacher collective agreement is Article A2, that says that the union is the sole and exclusive bargaining agent for teachers in the district. So when you sign a union membership card, and in BC you don't sign the card, but you become a member as soon as you become an employee of the school district, you can't negotiate for yourself. I remember when I started teaching, I had a colleague in West Vancouver who was at that time in his mid-60s. He started teaching in 1939 in West Vancouver, and every year he'd go down, the board would announce the salaries, he'd go down and talk to the superintendent and say, I really can't live on that, I need another $300, and they give him $300, or someone would get a better assignment, and that's not allowed anymore. The member gives up the right to negotiate for him or herself, Only the union can do it, and if the union doesn't do that fairly, they can be charged under the labor code for failure to represent fairly. And the principle there is, if you can't represent yourself, as that first point says, you can't negotiate for yourself. The union has a high obligation to represent you fairly. And so this means when the union gets tough with you, as it sometimes does, they have to do that. They've got a duty to represent, even to represent the people they may not want to represent. So it's really important to understand why they do what they do. And I'll tell you at the end, I'll suggest you shouldn't take it personally because it's actually rooted in law. So how to work with the staff rep, and this is really the most important thing, and it's really the flip side of what I would tell staff reps, and again, I haven't done this work. I last did it from 1989 to 1993, but it is my understanding that the workshops that I designed in those days are still essentially the workshops that are used to train staff reps now. So I think it's worthwhile investing time in a positive relationship with your staff rep. You can't pick your staff rep just as the staff rep and the staff can't pick their principal. Although I was with Kevin at a conference in Toronto last week, and I met a principal in Slovenia and learned that Slovenia, which is part of the old Yugoslavia, they actually elect their principals, which is interesting. The one-year terms, and they're paid less than their teachers. We didn't take notes on that, but I did learn that. So have a respectful relationship. It's in your interest. I also strongly recommend, and again, this is the flip side of what I would say to staff reps, you should meet with your staff rep regularly. If I suggest you have a meeting at least every couple of weeks, certainly no less than once a month, and these are meetings that you call, or they're just getting a routine of saying, is there anything going on that I should know about? Are there any concerns? Much easier to deal with something in its initial stages than with something, in fact, before the staff rep goes to the union to get advice, where you can simply keep your finger on the pulse. Really, really important. Now, not every staff rep will do this, but I think most will be very pleased to be given the respect that you say, how are things going? Any things I should know about? You should know some key elements of the contract, not all the contract. It's not necessary, but I'll later talk about some of the things that I think deserve your attention. Also, I think it's really helpful to know that the BCTF has some support to members that you sometimes can remind the staff rep of. They don't always know them, or you can help the staff rep to support your members in such a way that helps you maintain good relationships in your school. The most important ones are the BCTF rehab program, and that's the one where a person who's returning for work, who needs accommodation, who's struggling, can get some support to have their assignment modified so they're successful. And the internal mediation service, the IMS, is actually a dispute resolution service. When you have two colleagues going at each other, and it could be two colleagues within the BCTF, and I believe they'll extend that service, they have some protocol with QP to have some dispute resolution. They bring in, at no cost to you, trained mediators to resolve disputes. And you probably have all experienced something where a major cultural influence in your staff is some poor relations. Know about short-term disability so that you can you'd be surprised how many teachers don't know what access they have to supports when they're struggling. So the thing is, Jess, is there are lots of ways to solve problems in your school, and they're in the contract. So my view is nobody should ever come to you from the union and tell you about a problem that you haven't dealt with through the structures in your school designed to solve problems in the school and give teachers a voice and give you a chance to know what's going on in your school. So there are three in particular, and two apply to all schools. One is really more common to secondary schools. The school staff committee, which has in some cases precludes representation from management. I know North Vancouver has no union representation on the staff committee, or administrators on staff committee. Surrey does. I remember a debate in about 25 years ago on that. But the staff committee is a place where teachers can bring concerns. Don't discourage that. Better they get resolved through these formal processes in the contract than through an informal dispute that you can't control or know about. Department heads of secondary are another way for people to bring concerns to you, so you can use that instrument. And the staff rep, of course, is legitimate. Your door should always be open to that person, and that person should know that if they come to you before they go to the union, things are likely to be dealt with. Once it goes to the association office, all sorts of factors come into play that you can't control. If it goes that way, it's okay, but if you can do something to avoid that, that's a good idea. So if there's a concern, sometimes a staff rep comes and you can say, look, this one might be a good subject for staff committee, and that gets a lot more people involved. Perhaps brings some moderation to the discussion, or this one should be best dealt with by the English department, or so you have some choices. You're not always dealing with the staff rep on these matters. A bit about grievances, and I think there are probably very few of our members who have not faced a grievance, and it's a very stressful thing. I'd like to begin by telling you what a grievance essentially is. So grievances in Canada come into place in 1944. During World War II, there was not the right to collective bargain for most unions, and when there was a dispute in the workplace, instead of filing a grievance, they would go on what was called a wildcat strike. They'd put down their tools in the factory, they'd walk out and they say, until you fix it, we're not coming to work. And during the war, that was not a very good way to keep war production going, so there was an agreement, I think it was Bill C-44 or something, I can't remember, 43 or 44, in which the government said, we will recognize the right of the union to bargain collectively for teachers, for unionized employees, but you can't stop working in the middle of the contract. Instead of stop working and having a wildcat strike, you will go through a grievance procedure, the workplace will continue, and that will be a final resolution of the agreement that nobody can complain about. You can't fix it till the next time you're at the bargaining table. In fact, this court case that happened last week, one of the questions asked the other day on a conference call that Kevin and I were on was, can the teachers go on strike? And the answer is you can't go on strike during the life of a collective agreement. You can illegally, but as BCTF did in 2006, and they were threatened with a major fine that would have really shut down the organization. The idea is you grieve it, work now, grieve later. That's the sort of motto in bargaining. And although you don't like grievances, they're better than the alternative. The alternative is they put down their tools and walk out. So remember, I said earlier, the contract is mutually agreed to between the parties. The employer has said the contract, the grievance process is legitimate. And the labor code, in fact, has a section in it that says if you forget or don't want a grievance procedure in your contract, you think there's a better way, you can't do it. There's a grievance procedure in the labor code that is the default clause, and it goes into your contract if you forget or choose not to negotiate one. And a very important thing to understand is they can't grieve anything. A grievance is not just, I'm not happy. A grievance is an allegation that a term of the collective agreement is breached, and the Federation will sometimes try to grieve something when it's simply something they think is unfair, but it is not, in fact, a breach of the collective agreement. And what I realize here is, no, I'm looking for questions because I'm so carried away. I haven't read them, but there are no questions so far. Maybe they put me on mute. So about the grievance process, know the process, there's steps, and only the first step usually involves you. The first step, which can be skipped, involves the griever and in the school and the administration, the person administering the contract with the employer, and when it goes past step 2, it's sort of out of your hands, other than you're advising the board. When you meet with a member, have a recorder, have someone, it could be your executive assistant. If you have a vice principal, it could be a vice principal. It should not be another member of the union, obviously, but have someone there who can take notes so that you can focus on the questions, on the information, and not be trying to do two things at once. And make sure those notes are accurate, because if the grievance proceeds, the notes you take are evidence in what could be an arbitration. Also, never feel rushed to make a decision. The timelines and the grievance are there for a reason. They give you a chance to get some support, they give you a chance to get some information to see whether what you've been told is accurate, to interview people if necessary. It's usually, there's 30 days between the alleged incident and the initiation of grievance, and then usually 10 working days. It's Article A6 in the provincial agreement. It is 10 days between any meeting you have and your ability to make a decision. So very important to use those timelines. Don't feel rushed. Sometimes they'll put pressure on you. What are you going to do? Don't rise to that bait. Whatever you do, every decision you make, it can be precedent setting. And if you do something over and over again that is inconsistent with collective agreement, that can be invoked as past practice. they have something called estoppel, which they can stop you implementing a part of the contract because you've done it a different way over time. So be cognizant, and this is why it's important when you do things with support of your central office where there's a grievance. Make sure you know what past practice is and don't go setting precedent that will be harmful to everybody else in the province potentially. You are in one school in your district. The collective agreement applies to every school in your district, and in fact much of it provides provincially. So it's important when you have an issue to make sure that you know how this has been dealt with elsewhere. You can speak to your senior staff. They often know that. You also get the support of BCPC from the district office. They will call BCPC and they'll find out how this is dealt with in other districts, because it is in fact for the most part a provincial agreement. But I think that the most important thing is if you go on your own and in the end it does not turn out well for you or for the employer, when you connect with the district and you get guidance and direction from them, I think you're in much better shape. You are going to be looked after because in fact they own some of the decision.